Finally, and very briefly, Mr. President and members of the Court, allow me to summarize the basic principles relied upon by the Republic of Cyprus. First, acts of secession are not neutral facts about which international law has nothing to say. They are acts with legal significance and consequences, and they must be consistent with international law. Second, the above is particularly the case in circumstances where the act of secession is the result of an unlawful use of force. Third, the fact that the UN proposes terms for a possible settlement by agreement does not entitle any party to impose those terms unilaterally. Fourth, the UN Security Council does not have the power to amputate part of a state without its consent. And fifth, Mr. Chairman and members of the Court, international law applies to all international situations, however exceptional the circumstances.
Although this is the first time for the People's Republic of China to participate in the proceedings of the court, the Chinese government has always held great respect for the authority and importance of the court in the field of international law.
The principles of international law being interpreted in good faith and in harmonious and systematic manner allow us to arrive at the conclusion that the external self-determination is an extraordinary event which may take place only under extreme conditions. Historically, only colonial oppression is universally accepted as such an extreme condition, constituting a special case for external self-determination. The Republic of Belarus doesn't perceive such conditions in the Kosovo case.
State practice confirms that an entity created on part of the territory of a state without the support of the whole people entitled to self-determination is a priori illegal and cannot thus be considered as a state. Hence, the establishment of an ethnically constructed separatist entity, particularly one which survives by virtue of external political, military and economic support, is illegal both because of the violation of the right to self-determination of the population of the state as a whole and because of the breach of the principle of non-discrimination.
The Republic of Serbia submits that, firstly, the International Court of Justice is competent to give the advisory opinion in the present case, and that there are no compelling reasons that should lead the court to decline to give its opinion. And finally, that the unilateral declaration of independence by the provisional institutions of self-government of Kosovo, dated 17 February 2008, is not in accordance with international law.
Now I come to conclusion. First, Resolution 1244 does not affect the territorial integrity of Serbia. The final settlement under the resolution is to be a self-governing Kosovo within Serbia. Second, the final settlement envisaged in the resolution is to be negotiated between the parties and endorsed by the Security Council. No unilateral action can be regarded as such a final settlement. Third, the failure of the Ahtisaari plan did not determine the final status process. The interim period during which Kosovo is to enjoy autonomy within Serbia, being governed by the international administration, is still ongoing. Resolution 1244 remains in force in its entirety. Therefore, no institution has a right to unilaterally declare independence of Kosovo. Accordingly, the Russian Federation respectfully submits that the UDI was not in accordance with Resolution 1244 of the Security Council.